Hi, everyone. Welcome to our webinar this week on how COVID-19 has impacted third-party reproduction and other legal questions. We will be starting with our experts in just a few minutes. Hi, everyone. Welcome to our webinar this week on how COVID-19 has impacted third-party reproduction and other legal questions. While we're waiting to start, if you'll please use our chat room. When you join, introduce yourself to the panel and all the participants. So remember to click panel and all participants, type in your name, position, and your location so we know where around the country you are. If you want to ask a question, again, please use the chat room. We want to make this as interactive as we can. So type your question or your comment in at any time during the presentation. We're going to start in about 30 seconds. Welcome, everybody. Hopefully you've let us know who you are and where you're at and what you do by writing it into the chat and direct it to the panelists and all of the participants. I'm Lisa Reinhardt, and I'm really happy to welcome you today to a little bit different kind of webinar. We're going to talk about what the pandemic has done to third-party reproduction and some of the other legal things that have come up. And we've got a wonderful panel for you today. First, I want to say from me and from Monica and from Mary, we're thrilled that you're joining us. And thank you so much for what you're doing for not only our infertility patients, but for all the infertility providers out there. This is National Infertility Awareness Week, and hopefully we're adding to the Change the Conversation mission by sharing what we know, what we don't know, and all of our questions and answers to help us move forward during this really tough time. Today we're going to try and do a little bit different format, get through our material a little sooner so that we can have a lot more time for questions and answers. And we'd like you to please, as you think of them, write them in the chat and we'll hopefully address them right away. Just to give you a heads up as to what we're going to talk about today. We're going to take a look at, hold on a second, little technical difficulty. We're going to share some real life issues that gestational surrogates, donors, and intended parents are facing during this pandemic. We're going to discuss the impact of the shelter-in-place orders and the travel restrictions. I think you're going to be a little surprised at what's been going on and how hard some of our reproductive law attorneys have been working with these patients. We're going to look at what happened with egg donation and transporting gametes and embryos, and then consider how anything was done at all while the courts were closed, because some of you may know, and others may not, that across the country, court systems were completely shut down or only allowed minimum legal transactions to occur. Then we're going to talk about how the pandemic has caused us to change our third-party contracts and really take a long, hard look at them. And again, as always, how do we all move forward in a pandemic-aware world? Just to get us started, I'm going to share with you a really good question that came across my email this week, and it had to do with FDA screening. We all know that the FDA requires us to do screening of anyone who's going to provide tissue, particularly our donor gametes, our gestational carriers, etc. On Valentine's Day, the FDA came out with a statement with regard to the coronavirus, and I have it on the slide there. And as yet, they are not requiring any extra testing. They state that they are aware that some centers are going to be doing extra testing, but that this testing isn't necessarily available or affordable for everyone to get. they still are requiring eligibility determination, as we would expect. And they did add a statement that we may want to consider asking the donor for the following history if it occurred 28 days prior to recovery of HCTP. And that would apply to anybody who traveled to areas with COVID-19 outbreaks as defined by the CDC. It's going to be an interesting question because now it's become worldwide. Anyone who's lived with individuals diagnosed with or suspected of having COVID-19 infection, or been diagnosed with or suspected of having COVID-19 infection. Currently, there's no guidance as to whether a donor who presents or says yes to these questions is going to be excluded. And all the FDA is telling us is that they're going to continue to monitor it, and they'll issue updates as information becomes available. But just something for you to think about as you move forward in the third-party world is that we still have to pay attention to our infectious disease processes, testing, and what the FDA is going to require. So that said, let me tell you a little bit about our speakers today. I am really, really thrilled to have three phenomenal speakers. The first one we're going to hear from is Mary Ellen McLaughlin. Mary Ellen is the president and partner in Alternative Reproductive Resources, short form ARR, in Chicago, Illinois. It's one of the country's first egg donor and surrogacy companies. She is a nurse and a member of ASRM's Nurses Professional Group. Mary Ellen has a bachelor's degree and spent her early career in intensive care and is an OBGYN nurse. At ARR, she interviews and guides surrogates through the fertility journey and really is their strongest advocate. And that's only her primary role, because she also advocates for donors and intended parents and interacts with them throughout the entire process, because as you know, you get to know Mary Ellen, you'll know that her compassion for these patients, her nursing concern for their safety and well-being is preeminent in everything that she does. The two lawyers that we have on the panel include Margaret Swain, better known as Peggy to us, and she's an attorney in private practice in Baltimore, Maryland. She's a former surgical delivery room and IVF clinical nurse and focuses her clinical practice on assisted reproductive technologies, adoption, and guardianship. Peggy's a fellow of the Academy of Adoption and Assisted Reproductive Attorneys, where she chaired the Art Committee and served for 4 years on the Academy's Board of Trustees. And she's currently the director of ART and a trustee. She's a long-standing member of ASRM and has co-chaired and presented at many of their postgraduate courses. She was instrumental in founding the Legal Professional Group and has been on the SART committee and membership committee and many, many other sections of ASRM. She's also a member of the ABA and the Family Law section of ART. Peggy has authored a number of textbook chapters, is a frequent lecturer. She's a fellow of the International Academy of Family Lawyers and a board member of the Family Formative Charitable Trust. In 2008, she was recognized for her advocacy on behalf of adoptive families, birth parents, and children, and was honored as an angel in adoption. And I hazard a guess, Peggy's an angel in a lot of other areas as well. Nidhi Desai is an attorney in private practice, practicing in the areas of assisted reproductive technology and adoption. Her office is in Chicago, but she works internationally with families to assist them in gestational surrogacy, egg and embryo donation, and adoption. She currently serves as the Deputy Director of ART for the American Academy of Adoption and Assisted Reproductive Technology Attorneys and has served as a member of its board. She's also a member of the board for the Kevin J. Lederer Life Foundation, which is a not-for-profit that helps individuals and couples who are struggling with infertility through education and financing. Nidhi has been extremely instrumental in drafting and passing laws to protect the rights of families born of assisted reproductive technologies in Illinois. First in 2005 with the passage of the Illinois Gestational Surrogacy Act, which has become a template for many states across the country. And then most recently in 2015 with updates to the Illinois Parentage Act to protect children and families born of gamete donation. Nidhi has also served on the SART Executive Committee. She was also instrumental in starting the Legal Professional Group and is well known in ASRM for her many educational opportunities that she provides. She also is on the Leadership Council of the Illinois local affiliate of Resolve and has taught and done a lot of education for them. She works with the Illinois State Bar Association Genetics and Human Reproduction Task Force, and that was formed to examine and develop policy recommendations for a myriad of issues surrounding the new technologies. Nidhi works with families across the globe and has been not only instrumental in the legal considerations in the United States, but also in other countries as well. So you can see we've got a very diverse and well-versed panel, and I'm excited to bring them to you. We're going to start with Mary Ellen. And as I said, Mary Ellen works with a matching company, and she is going to tell us some tales from the front that are going to spur the rest of the conversation today, because she has some very interesting stories of what the pandemic has done specifically to gestational carriers and to egg donors. Mary Ellen, welcome and thank you.
Hi, Lisa. Thank you so much for that lovely introduction. I'm just going to start with one of our most interesting stories. It was a story, these started prior to here in Illinois, we have a shelter-in-place order. So all of our fertility centers were following the ASRM guidelines and put a pause to all of fertility treatments. So what happened was that everyone pretty much did put the pause on, but prior to putting the pause on, we had a case that was where we had an embryo transfer planned for a gestational carrier who was planning to come in at the end of March for her transfer. She had it all set up. She was coming right into downtown Chicago, and her parents met her, and it was all set up through her work. She came in, she had her transfer, she went home and returned to work, where she was told that she had to go home for a 2-week quarantine, unannounced, unplanned. And when she was at home, they told her it had to extend for a 20-day quarantine. It has since gone on to be a potential wrongful termination suit. It's ongoing. She is still currently working, but it's a very interesting case, as her company knew she was traveling to Chicago. They knew that she was coming to a state that had a shelter-in-place order. Surrogates will continue once things open up, coming to Chicago potentially, while our state is potentially going to continue the shelter-in-place order, perhaps opening up some services. We're not sure what's going to happen yet. We're in a shelter-in-place until the end of April, but we're going to see what's going to happen. But thankfully, to some wonderful lawyers, one of whom is on the panel, with some excellent advice, we took very good care of her and got her connected in her home state, which is Missouri, with some very good attorneys. And she is being well cared for there. But she contacted me on this week with her story of ongoing issues, and we got her very well connected there. Another issue we had was someone who was in the midst of an ERA biopsy from Iowa when our shelter-in-place order was initiated. She was planning on coming. She has a husband, with her husband bringing her for her biopsy. And as her physician here in Illinois, the RE wished her to come here for her ERA biopsy, and had done all of her monitoring in her home state of Iowa. As we do work with fertility centers throughout the country, or work with, surrogates throughout the country in states with excellent laws, where we can get pre-birth orders. And she was planning on traveling, and her husband did speak to his boss and was told that he would have to quarantine at home for 2 weeks if he came to Illinois, because it was a hot zone, less the shelter in home order, but because it was a COVID hot zone. So he was unable to come. And we were talking through all the potentials for her. Her intended parents were potentially going to pick her up, but that would put them staying overnight at some place. And then her husband has a autoimmune disorder. All of his doctor's appointments were being canceled. So she decided that if his doctor's appointments weren't going to be happening in her home state, that she felt the risk was too high to be traveling at all. So she decided to cancel the cycle herself due to the COVID pandemic. So another story of the pandemic canceling a cycle. We had another situation where a surrogate just delivered recently. She was scheduled to have a C-section in her home hospital, which has become a smaller local community hospital with a level 2 NICU. And her wife was going to come with her initially, but because of the pandemic, she decided to have her wife and her parents not come with her. She went in and did this scheduled C-section without any of her own support system, as she did not want to have any of her support system put at risk. Her intended parent was absolutely wonderful. She was allowed one intended parent to be with her, really stepped up, came in with her, was in the OR with her, and delightful, visited with her, brought food to her, was absolutely fabulous throughout. But she had a 2-night hospitalization post C-section with none of her own support system there with her. So that was her choice to risk any type of exposure to COVID, but these are the steps that people are taking due to the pandemic. And then very early on, we had another surrogate very early on in the pandemic. We had another surrogate in Tennessee. This was 6 weeks ago, whose parents were from New York. And because they were from one of the first hot zones, the hospital would only allow one parent in at a time. And both of the parents came with their child. So their older child was never allowed in to see their new sibling. One parent at a time was allowed in, which thankfully the surrogate's spouse was allowed in to be her support system. But as you can see, the pandemic has caused lots of issues with cross-state people having their lives upset. And I think that once we start bringing surrogates cross-state and egg donors cross-state, we've also had egg donor situations with similar changes in travel plans, who's going to drive them, who's not going to take them, changes, multiple exchanges of who's going to take them, questionable whether they're going to come for their retrievals right at the end prior to when they were in cycle, right, and towards the end, well into their cycle, and getting close to their retrieval times where their cycles were not canceled. So once we open up, if we are still on a shelter at home or a partial shelter at home, and states from where they're coming consider us a hot zone still, if they are told they have to shelter at home upon returning, what will that mean to their income? If they're told, they are not told that they have to shelter at home, but upon returning, their employer changes their view and at that point tells them they have to shelter at home, what will it do to their income? These are things we're going to have to see once they occur. Unfortunately, I think we have to look to the future and try to deal with them now, obviously. There's also the fact that they're traveling. It's not like local patients. What will they come across as they're traveling? It's not like filling your gas tank and being very careful locally while you're filling your gas tank. It's what happens when you're traveling and you have to use a restroom in a gas station and eat when you're out. It's not the same as staying home, as we're told now, and collecting groceries and having them put in the back of your car. It opens up a whole myriad of issues for surrogates and egg donors once they start traveling. So that is what our situation was prior to our shelter at home order. And I'm sure that many people have similar stories. Thankfully, we did not have any international births at this time. And we've been very lucky with the births that we've had and the cycles with egg donors that we had prior to our shelter at home order. So those are our stories from the front. Thank you.
Mary Ellen, thank you very much for sharing the issues that have come up with you. And I know it's not going to just be in the matching company's lap. A lot of these questions and having to educate our patients, donors, intended parents is going to have to come from the providers. And so I think you pointing these out, and now we're, you know, as we move to Nidhi and Peggy, maybe we're going to learn some of the answers and hopefully be able to deal with this a little bit easier. So Peggy and Nidhi, I'm going to turn it over to you, and we look forward to what you have to tell.
Great.
Thank you.
Can you hear us? Yes. Okay. All right. Well, good morning, everyone. We are thrilled to be doing this cross-disciplinary talk to hopefully answer some of the questions you have and shed some light onto what's going on our side of the road, if you will. So thank you to Lisa Reinhart for inviting us to speak today and for collaborating on these issues that are of concern to you. So what strikes me the most at this time is that our partnership with agencies and with fertility centers has never been more important, because the more consistent all of our messaging is to our patients and clients, the better outcome we will have for all of our families. All of us have the ultimate goal of helping intended parents achieve their dream of having a child. First and foremost, this process needs to be safe, though, and safe not just for the patients, for the gestational carriers, for gestational surrogates, and for their spouses, but also safe for you. And I think the key to all of our success during this time is going to be communication and our ability to pivot when necessary and make adjustments as the situation on the ground changes. And I think as you were discussing last week, the situation is going to ebb and flow. So it's not going to be the case that we have a very stable and steady way of doing things. So it'll be incumbent upon all of us to make those changes as we need to. So, but at this point, I think we are settling into our new normal, and we're all dealing with the fires that we need to put out, as Mary Ellen was just talking about. And we couldn't have imagined any of these things a few months ago. So the first thing that we were asked to talk about is the issue of travel for international parents. It's a significant issue both for those who are coming in for evaluation and treatment, and of course those that are coming in for birth. So Lisa, if you could advance the slides, that would be great. I first want to talk about the way things used to be so that it makes a little sense to you in terms of the issues that we're dealing with now. It used to be that we would meet with international clients prior to, of course, any medical treatment happening, and we would have our consults. We would talk about the risks that are involved in the process and the particulars that are incumbent on their contract, the issues that needed to be included that might be specific to their situation, but also those that are general to each and every arrangement that flows through. And then, of course, everyone would sign their agreements and we would wait for a pregnancy to happen. And right around week 14 to 20, depending on what your state you're in, the attorney with whom you're working to establish parentage would start doing that, whether it be by way of court hearing, or in Illinois, we have an administrative process we can use in lieu of a court hearing. We can do either. But all of it pretty much is done pre-birth so that we can make sure that when The clients are here, their parentage is secure, and then we are really working on the next step, which is getting them home. Lisa? All right. So parents arrive typically pre-birth, and once the baby's born and the baby's out of the hospital, they will then go get their passports. In many cases, they will visit their embassy to start their family book or whatever the equivalent is to make sure that their child is registered at home and has all of the safety and security that they need when they return home. And so typically it used to be then they would just get on the airplane and go home. But due to COVID, there have been a number of proclamations and a number of changes throughout the last couple of months, first beginning in March. And those proclamations prohibit people from coming into this country if they are from certain areas. They do not apply to US citizens or to any alien, which is the term in the statute, who is a parent or legal guardian of a US citizen or lawful permanent resident, or applicants with an urgent matter that have to travel immediately. And then there's guidance on the embassy website to request an emergency appointment and try to plead their case to come in. So these are the two hooks that we have been trying to use to get people into the country. It's been challenging in that a lot of people have hit a roadblock, and that roadblock comes because we're trying to get people into the country before their babies are born, so that the minute the baby is born, they're in the hospital with them, they can make medical decisions, they can take legal responsibility and absolve the gestational surrogate of any responsibility for the child. But the problem, of course, arises because this is during a pregnancy, and so at that point they are not a parent of a US citizen, which they will be the minute the baby is born. So I won't get into the details of this because I think for purposes of this webinar, it's less important than knowing that there's a significant amount of stress that's been involved for these clients as they are trying to make their plans. So we're getting clients, we're getting calls from our clients saying, I'm stuck in Malaysia, I can't get on an airplane, I don't know what I'm going to do when the baby's going to be born. And the question for us has been, well, what do we do next? So the process for us has been twofold. It's been one, trying to continue to help them get into this country, but also to make provisions for these children if they can't do so. So each state has a different mechanism for doing that. In Illinois, we can create a guardianship situation so that someone can temporarily take custody of the baby until such time as the attendant parent can get here. But you can imagine that causes a lot of confusion at hospitals, from the most basic things like the birth certificate. The person who comes around getting the birth certificate information needs an original signature from the parent, and the parent's not here to give an original signature. So there has been a lot of thinking on the ground in terms of Department of Public Health making exceptions for that, sending documents back and forth electronically, and allowing for these situations to move forward. But I've had more than one occasion where we've had to talk to the hospital because the hospital wants the gestational surrogate to be the mother of the child because they can't wrap their brain around how to deal with the situation. So it takes, I think, some listening and some patience and knowing where they're coming from in order to persuade them that no, she's not the legal mother. That's not an option. We have to figure something else out that's going to work for all the parties and go from there. So once we deal with all of these issues, we're of course waiting for the intended parents to get here. And then once they do eventually get here, we have a whole nother issue, which is how do they get out of here? So with that, I'm going to turn that over to Peggy to talk about to continue our conversation.
Thank you, Nidhi, and thank you everyone for joining the conversation today. I hope that you do feel comfortable sending us questions, and although Lisa said we'll get the answers, not so sure we have all the answers, but we can at least provide a template for thinking about how to resolve some of these issues. So you have this nice family here, they have their baby, they're ready to go home, and all of a sudden you got to hit the stop button because they don't have a passport. Next slide, Lisa. So here's what has happened. On March 20th, the United States restricted the issuance of passports. As of now, passports are issued only to those with qualified life or death emergencies. And I would like to point out that in my mind, this is a qualified life emergency as opposed to death, but they don't really see it that way, unfortunately. A qualified emergency is a serious illness, an injury, or death in the traveler's immediate family that requires travel outside the United States within 72 hours. So the usual protocol for our international intended parents is that when the new birth certificate is issued for their child, they can then take that birth certificate to the closest passport center or have an expediting service take care of that for them and obtain a United States passport for the child. We have a birthright law here, so any child born in the United States is automatically a citizen. The child can enter at a port of entry in the home country with a US passport, and then later the parents can arrange for the issuance of a passport from the home country, usually. Well, without that passport, because they're not being issued, clients can't just hop on that plane and go home. Unfortunately, we have yet to receive any update regarding when the restriction might be loosened or even completely rescinded. So we continue to deal with those issues. So what do we do about it? Next slide, Lisa. Important to counsel the clients to be working with a knowledgeable attorney in their home country. This attorney can help them investigate the home country's policy regarding emergency travel and can help them navigate getting that consular appointment to discuss what the options might be. For instance, and for some countries it's easier than for others, a home country's embassy within the United States can schedule an appointment with the clients and perhaps have the child's home country passport issued while they're still here in the United States. Or the country might have an alternative for emergency travel. For instance, in France, there is a process called laissez-passer, which allows French citizens to enter the country without a passport, although they will need to very soon after that obtain the French passport for their child. Some of the other problems that have contributed to travel issues for our clients are delays in the issuance of the actual birth certificates because the divisions of vital records of the health departments are effectively closed or are working on very skeleton crews. The employees are working perhaps from home, but this puts a significant delay on receipt of birth certificates. And in the case of gestational surrogacy, and depending on what state you're in, but as a general matter, that original birth certificate is amended so that the new birth certificate that is actually issued by the department has the names of the legal parents and does not have the name of the gestational surrogate. In each division of vital records, there may only be one person who handles that particular type of certificate. And if that person is not there, then there is an even longer delay in getting those certificates. And then it used to be that after The birth record information from the hospital, along with the order, was received by the division. An amended birth certificate with the names of the legal parents could be obtained by the intended parent walking in to the division with a request for that birth certificate, and they could get it on the same day. But that is not happening now because all of the lobbies are closed to in-person traffic. Some countries are going to require certification by, okay, there's about 8 different ways of pronouncing this word. I'm going to say apostille, but this is a special certification that generally is applied by the state, Department of State. And because those walk-in lobbies are closed, it takes a much longer time to get those if they're even available. So certification of documents continues to be a little bit of a snafu for our clients too. Okay, Lisa, next slide, please. So what about egg donation? There's a lot to think about here, especially, there's always a lot to think about with egg donation, but especially now when you think of the increased risks involved with exposure to the virus. Lisa, next slide, please. Of particular concern is that an egg retrieval for a donor is clearly an interventional procedure, but it is not done for the medical benefit of the person undergoing the procedure. It's for someone else. So whether there is any ethical way that egg donation can be done during a time of increased risk, that's a dilemma and something that I really think bears further discussion. It requires multiple visits to the facility, which again increases exposure risk and also potentially is straining the resources of the facility. Also, when you are having discussions with donors, there are so many unknowns about the long-term effects of exposure to and contracting COVID-19. There's a thought that if you were exposed and you actually contracted it, even if you did not have symptoms, you now have antibody immunity. That remains to be proven. We also don't know if undergoing any type of interventional procedure puts the donor into a new category of risk for severity or contraction of the disease. So any discussion with the donor is going to have to include a reference to the donor assuming the risk for those potential long-term effects, whatever they might be, because we're not 100% certain. I also think that intended parents really need to balance the financial loss of not working with a donor who they have selected and for whom they have either paid a deposit with a bank or have invested an amount of money for the evaluation of that donor and for their own medical procedures, with the understanding now any of those FDA clearance tests that the donor or the intended parents underwent are going to have to be repeated. The intended parents may also lose the opportunity to work with this particular donor. They have to balance that with the increased risk of potential complications for both the donor and the intended parents, but also potentially for the donors. I do not know if there is any research that shows embryos that are created with ova that have come from a patient who maybe has COVID-19 but has had no symptoms, if those embryos are at any increased risk or if the pregnancy itself might be. Is egg donation an essential service? I think if you ask intended parents, yes. And directed egg donation, I think much better argument for that as opposed to the use of eggs that have already been retrieved and are banked. So next slide, please, Lisa. A really thorough, informed consent has to happen with that donor. This is meant to be a discourse between the patient and the provider. So any types of materials, in addition to the spoken verbal information, I think is helpful. It needs to be thorough. And again, the question is, how thorough can you be when most of the information really is unknown? A very careful history and physical, clear documentation of the findings. From a legal standpoint, it's important to include in any contract that the donor really cannot be held to a contract breach provision that specifies a time within which she will undergo evaluations and retrieval. Also, a hold harmless clause if it turns out that she had COVID-19, as long as she was unaware or reasonably could have been unaware. And then an agreement by intended parents and also donor to follow all government restrictions, meaning federal government, local government, and CDC, FDA recommendations as well. So Lisa, can I have the next slide, please?
Excuse me, Peggy, it's Monica. There's a question that in terms of the COVID consent for the donor, if you have a COVID consent for your center and you're using that for everybody and it's a one-time consent, is there anything specific in there that needs to be for the donor, or can you have that just in addition to your existing donor consents?
So if the donor is signing a usual consent for the procedure, for the process with the fertility center, and then there is an additional informed consent regarding COVID,
Right.
that's probably sufficient, but without seeing the particular documents, really hard to say.
Okay.
Okay. Like I said, non-answers from the attorneys, but always qualified, right? So Lisa asked us to look into any potential problems or problems that have actually occurred with not storage of genetic material, meaning embryos, sperm, or eggs, but shipping, because of the different types of restrictions and problems across this country, but also internationally. So I looked into this a little bit. I actually spoke with a representative from one of the companies that handles the logistics for packing and storing those embryos for shipment. So Lisa, could I have the next slide, please? Online, I looked at about 6 different companies, and I really could not find a lot of information that was particularly responsive to the pandemic. One of the companies did post this statement on its website that it was continuing to offer services as usual. First priority was health and safety of employees, and then clients, patients, and suppliers. So they were continuing with all of their shipping plans. Now, I actually spoke with the representative from the company who had this particular statement, and he indicated to me that all of the shipping of genetic material has been really pretty flat throughout the entire pandemic. They do a lot of business with China as well as domestically here within the United States. So they were able to follow the curve throughout the infection in China, and then as it went through Europe, and then here pretty uniformly, business has been flat, although they have been hearing from many of their customers, meaning fertility centers and banks, that those businesses are hoping to gear up in the next couple of weeks, and he expects a large influx of business at that time. He was very nice and went on to describe how they do their packing and the types of testing that they do to ensure that there is no variance in the temperature during shipping, and they do real-time tracking of the packages, and not just where they are, but the temperature and the condition of the package to make sure that there is not a variation that could endanger the contents. So that's neither here nor there for this question, but they, as I said, have continued with their services when they are requested. Next slide, please. So some questions that just generally are pretty basic, but maybe important for clients to ask any company that they're engaging with for shipment. Has your company experienced delays? Have they impacted the shipments in a way that could potentially be harmful to the materials? Have there been extraordinary steps taken to avoid this? Any particular routes or points of entry that were more problematic? What about insurance? So I did speak with the rep about this. They offer two well, it's the same type of insurance, but the benefits are either $25,000 or $50,000, and this covers any of the potentialities that could be problematic. So shifts in temperature, a breakage in the storage equipment that is shipped, if the package gets lost, those kinds of things. They do not, of course, guarantee that when the genetic material arrives, that it's viable for use. I think patients really need to consider, especially during this period of time, is it worth the risk? And is it worth the worry? And can it wait? So some points for your clients to be thinking about. So, okay, Nidhi, back to you.
Okay, so I've been told by Lisa that we need to pick up the pace. So if I'm talking too fast, just slow me down. Anyone can just put that in the Zoom chat, but we're going to try to get through this next part with as much efficiency as possible, because we want to make sure there's time for questions. So this is a question for all of us, right? What keeps you awake at night? And from talking to my friends at fertility centers, I feel like there are several issues. One is making sure that any decisions are made with the utmost regard to both patient care and safety for all of your employees. And two is sort of respecting the broader context of the world that we're living in now. Is it even ethical at this point to be carrying on with treatment particularly for patients, as Peggy said, who are deriving no benefit from the procedure, at least not from a medical standpoint. So I think we're all dealing with our own nightmares, and we're all dealing with our own concerns late at night and in the middle of the night. And so from our standpoint, we just want to kind of fill you in on what our goals are and how we're trying to deal with the issues that we are confronting day to day. So now we're switching gears and we're thinking, what do we do moving forward? How do we counsel our clients to make sure that when they move forward, they have a realistic idea of what's to come? And some of it is we're learning on the job. We're every day finding out a new circumstance we hadn't even thought of the day before. But so we're going to spend a little time about contracts moving forward and amendments to existing contracts. So with contracts moving forward in this post-COVID world, Lisa, can you forward 2 slides, please? There we go. Thank you. The first thing is setting client expectations. And I feel like this is a completely different set of expectations than we had maybe 3 months ago. Or we're thinking about delays that may be now going on, new uncertainties about travel. You heard Mary Ellen talk about the client who couldn't come in from one state to the other. Control of pregnancy. What if they can't come into the delivery room? That was a great story, but you could very easily imagine a circumstance in which a gestational surrogate wanted her husband in that C-section room and not the intended parent. So there are sort of these images of how things are going to move forward and fantasies that people are going to have to let go of if they're going to proceed in this time. And because we don't know when this time is going to end, I suspect that people are going to want to move forward as soon as they can.
Excuse me, Nikki, we have a couple questions for you and Peggy. Do you mind if I interrupt? Since
Sure, absolutely.
I already did anyway. So sorry. So one question is, do you think we need a form? Do you think we need to add a form for any future embryo donation that was created during the pandemic period? So fall of 2019 through who knows when, 2020, that declares that genetic parents were not positive for COVID or had symptoms, even if they're not symptomatic. It could be years before some of our clients donate, but it's just a thought.
Right. So I think this is, it's going to require more thought than we can deliver this quickly. But I think a couple of things. One, it definitely should be acknowledgement that this was made, this embryo was created during this COVID pandemic. And then if there was testing, certainly it doesn't hurt to put it in there. But I wonder if it needs to also include this idea that the day that they came in for the test, they weren't COVID positive, because we don't know if the next day they would have been COVID positive or if a week ago they were. The testing is so limited at this point in terms of how much information it's providing that I think that, you know, if you're going to create that sort of document, it needs to acknowledge that as well. Peggy?
I would just say that if you're going to document something like that, it should say the test was negative, not that the client did not have it, because we're getting false negatives and false positives. So you just want to document exactly what happened.
Yeah.
Okay, and then Lisa, you covered the FDA in a quick slide, but we have a question about, is there specific recommendations regarding how to screen oocyte donors, specifically regarding COVID, not just blood work, but new questions, exams, new testing, or new time frame?
Right now, I have not read or heard that there's anything new other than you may want to ask them those questions, but what they wanted you to even do with the answers to those questions was not addressed. So, you know, generally, we're not going to put anybody through a cycle who's actively ill. We are probably going to be looking at holding off on putting somebody through a cycle who is living with someone who is actively ill. It kind of left it up to what the general consensus is and common sense. But I will be watching it, and if I hear any more, I'll be happy to share as it, you know.
Okay, thank you. Sorry, Nidhi.
So as we're, oh no, don't be. As we are looking at these new arrangements, one of the things we're trying to figure out is how do you deal with all of these contingencies? What if, for instance, a gestational surrogate doesn't feel comfortable going to a medical screening? Who bears the risk of that? Who bears the responsibility for that? And of course, there are economic consequences to that for the intended parents and time consequences as well. So one of the things we've been giving a lot of thought to is how to create a framework that is flexible, but also will consider all of the variables that can be at play. And so, for instance, one idea is to think about all of the restrictions in place, whether they be CDC, local, or statewide, and make agreements in the contract to follow the most restrictive of those scenarios. But I also think this is going to come down to the conversation with the mental health professional, with the agency, as to how conservative people really want to be during this time frame. People have different levels of fear. Some of them are healthy levels. Some of them are wild disregard for what's going on. And then some may argue that others of them are too conservative. But this is much like the issue of pregnancy termination and reduction, where you need to make sure there's a meeting of the minds on that issue, because once the process starts, we're not going to be able to force somebody to go to a medical appointment if she's not feeling comfortable doing so, or if she feels it may jeopardize her family in the process. So I think a lot of upfront consideration is important. And it also begs the question, I've been thinking a lot about this the last couple of days, of the order of things. I mean, oftentimes we wait for medical clearance in order to finalize legal agreements because we don't want to move forward in the event that the surrogate's not medically viable as a candidate. But in this day and age, it might make sense to think about this issue of, if people are not on the same page in terms of risk, and are they willing to take certain assumptions of risk in this process, like they might get COVID, or the child, the appointments may be delayed because someone's not comfortable going to an appointment. Liability issues, I think, need to be addressed. All of those things, I think, are unique issues that people really haven't thought about. And Peggy and I are both seeing that in our practice when we're dealing with clients who have signed agreements and are now moving forward and having to put a different lens on this. It might make some sense to really start digging into these issues with clients before medical clearance, because then they're going to be in a huge rush to move forward, and all of these issues are going to rear their heads. Slide, please.
Excuse me, another question that seems kind of relevant to what we're talking about. So the question is, we are not currently cycling donors or GCs, but when and if we do, should the egg donors' spouses or partners be required to sign the COVID consent?
I can tell you from the legal standpoint that anytime a donor is entering into an arrangement, we have the spouse as part of the contract. And that's not because the spouse can say you can donate your eggs or you can't donate your eggs, but there are medical risks involved. And so those medical risks could impact their family. And so just so that they're part of the process and they understand all of that. I think given that logic, it might make sense to sign consents, particularly if in the surrogacy context, you do that with their spouses. Maybe?
Thank you.
Did you want to add anything, Peggy?
Oh, sorry. No. Well said, Nidhi.
Okay. So I'm going to just stop there because we are, I think, running into a little bit of time issue, but I want to leave you with a few thoughts. And if we could move the slide, please. So I think some of the biggest issues that we're going to be confronting moving forward, number one, are delays. Number two are levels of risk, a threshold for each party, for the intended parent and the surrogate. She may be wanting to move forward because she wants to get pregnant and she has a certain time frame in her head, where the intended parents are very reticent to send her to a fertility center, even if they are taking precautions and think it's okay to move forward. Attendance at screening and OB appointments may be impossible from time to time based on the situation on the ground. Attendance at birth may be impossible, and making contingencies in the event that the intended parents cannot come are going to be really critical for anyone who is not local at this point. Slide. And finally, we talked a little bit about this, but figuring out where the risk is going to fall in these situations is also going to be another piece of the puzzle. Do the intended parents bear the risk of the delay, or does the surrogate bear some responsibility for that too? If a cycle is delayed for 4 months because of COVID, does she get some sort of compensation in the interim? Or do we all agree that this is an event past anybody's control, and so each party is going to share some of that risk? But at the end of the day, it's the meeting of the minds, I think, that's going to be particularly fundamental in moving forward. And regardless of all of the preparation we try to do, there will be issues that come up during the course of the pregnancy. So with that, I'm going to turn it to Peggy to talk about what's going on with our clients right now who have entered into agreements but have not yet moved forward.
So Nidhi was talking about the post-COVID-19 world. I'm going to talk about what's happening today and how we can deal with the situation as it presents itself now. Slide, Lisa. So a couple of different categories. The first is a match has been made, but there is no contract yet. So we have people kind of in limbo. They were waiting for that medical evaluation. I think you, as the nurses and practice managers and people on the front lines, can encourage those clients to remain in close contact with their agencies, with the fertility center, and really with each other, because that's where the real bond is going to be. And as Nidhi mentioned, suggest starting the legal portion before the medical evaluation, because it does save time later, but everyone has to be 100% clear about the financial risk, because that is a risk the intended parents bear. They're paying for the legal work, and if the surrogate ultimately is not medically approved, that's money that is already paid and is lost to them. Next slide, please. Okay, so now you have the contracts. They're finalized, they're safely tucked away, and now we have this. That contract has got to be an elastic instrument and subject to changes as need be, but you can't change it until both parties agree. Next slide, please. So the first step, of course, recommend to the clients that the contract be amended to reflect what's going on in the world. There are many issues to be addressed. This list is not exhaustive, just suggestions. So we need to change the trigger period of time with the trigger for the period of time within which the number of agreed upon embryo transfers will occur. Usually we say something like gestational surrogate agrees to undergo up to 3 embryo transfers within a 12-month period of time, beginning with the execution of the agreement. So want to consider changing that to beginning with the first embryo transfer. Or other modifications that are more realistic in light of what's going on. The suspension of any ongoing monthly stipend. While nothing is happening, it seems reasonable to suggest to the surrogate that we either don't pay that monthly stipend, or because it is meant to be a liquidated expense account, so to speak, switch it to reimbursement for specific expenses that are actually incurred during this period, this downtime period. Really, really important. Assignment of a suitable person to care for the child if the intended parents cannot travel. And it should be a person who is relatively local or is at least in the United States and can conceivably get to the hospital if the parents cannot. Language about avoidance of exposure to the virus, and that can be structured in any number of ways, but important to include that. The purchase and use of appropriate personal protection equipment. As Nidhi mentioned, persons who will be present or may be present during delivery. Most of our contract language now says something like, to the extent within the surrogate's control, everyone agrees that so-and-so will be present, and that should cover you. Other language might say something like, subject to hospital policy, intended parents may be present at the delivery. That probably is going to cover you. If it's not in there, something like that needs to be included now. Might caution clients to begin the parentage process earlier because it's taking longer, because, and we'll talk a little bit more about this in a minute, the courts are not open. And delays with birth certificates also need to be acknowledged with your clients. So next slide, and Nidhi, back to you.
So let's talk a little bit about the final step in the process, at least for clients who are not trying to travel out of the country. And that is the establishment of the final legal process, but the establishment of parentage and what's going on with our courts right now. So both in Illinois and in Maryland, we have an e-filing system that allows us to file our cases now without physically attending the court. So we file them, and then in some jurisdictions, they're allowing for remote hearings. In Illinois, or at least in the county in which I practice, they're only allowing them for situations they consider to be emergencies. There are some cases that the paper itself, the documentation that you provide, is enough to get a signed order, but everything is changing. So as recently as yesterday, and this is actually a pretty funny story, I laughed out loud when I was reading this email. My paralegal told me that we had a case and it's an international client. They entered the order. Ordinarily the next step is you go and you pick it up from court and you take it to be certified. So the clerk was trying to help us figure out how we certify the case. And so she said, okay, there's this number you need to call the number. So she calls the number and we have to make an appointment, and it took a couple of calls to get a call back. He told her to show up yesterday at 10:45. So she goes to court to get it. And then he said, well, I can't open up the whole register just for one person, so you have to call in. So she calls this number so that we can presumably make payment and start the process to get these orders certified. And the reason you need to have them certified is so that they're official, so that we can send them to the Department of State and get them apostilled. So she calls a number and literally his phone rings and he picks up the phone. He had no idea where that number was going. So people don't know what's going on right now. I feel like most people are trying to do their best to accommodate us, but everything is taking longer. And so that process, which usually would have taken, 3 to 4 days, is now taking at best a week and a half. And that's because we have pretty cooperative people. I know of cases where it's taking 3-4 weeks just to get anything done. The next step in the process then is getting the apostilles that Peggy was discussing earlier. That now you can't walk in and do it. So you send it in by FedEx, you send them a return FedEx, and that adds a number of days onto the process. So I think Peggy and I have both been lucky in that we're in jurisdictions where we can continue to do business. Everything is not completely shut down, and people are trying to be mindful of the fact that these are time-sensitive issues, but there is a certain amount of patience that has to be involved in all of this, both from the client standpoint and from the agency standpoint. And with both of our courts, we're in this situation where the courts are closed. You can't just walk in as we used to and present a case. It is a very deliberate process that you have to go through, and very dependent on how the judges are feeling about the safety, of course, of their courtrooms and what they consider to be emergencies. Peggy, was there anything you wanted to add for?
So only to say that in some courts, there may be only one judge who reviews these particular types of pleadings. So if that judge happens not to be the one or two of the judges who are on that day, it adds another layer of delay. So starting these parentage procedures early is, I think, a good idea. And that's what we got for you. So we'll be happy to try to obfuscate things even more by answering questions.
Okay, so here's one. Are there time frames for egg donor contracts? So the legal was quote unquote complete in January, but now the cycle's delayed. Is an update or an amendment needed?
It depends on what the contract says. Most of them will probably say something like all parties agree that this procedure will occur within the next 6 months. Hopefully it also says if medically feasible, but even in that case, not a bad idea to have some type of an amendment. What do you think, Nidhi?
I think it's super easy to do an amendment if the contract has expired. Moving forward, obviously, people are changing their language a bit to, I think one of the things Peggy and I have discussed is, starting the duration of the agreement when the first cycle starts, so that that's when the clock starts ticking. Because if you have to wait 3 months to even get in the door, that's not going to be a sufficient time frame. So, or just making it last a year. But chances of a donor even being available a year from now, if that's how long things play out, is another question entirely. So I do think it's important and it's necessary for its enforceability to have a duration, which going forward will make them longer, and looking back, it's very easy to do an amendment.
Nidhi and Peggy, I just want to step in for a minute and say thank you very much for all of the information. I think it's been very helpful, and I think, it's making people start to think about, there's a whole other piece to third party that in the offices we don't always think about, because we just kind of hand it over to you guys. And we need to be aware of it as well. So I appreciate it. Monica, do we have more questions?
I have one other one, and this is on somebody's own gametes. So is there any information about the safety of fertility preservation or banking of one's own material, genetic material or gametes at this time? Is anything known about the possibility of COVID-19 contaminating specimens, and does anything need to be mentioned in the consent form for this?
Can I just jump in on this one? One of the things that I learned in doing last week's presentation, and I've been monitoring, is can sperm, eggs, and embryo carry COVID-19? Right now, we don't have any substantive data that says yes. So our understanding is that the virus is not carried in semen, sperm, oocytes, or embryos, or found in uterine lining or placentas. But we're still gathering data. This is still really, really new. And there are still questions, and I know there are some other webinars that are happening even today as we speak about what goes on in the lab. And a lot of people are testing the virus in different environments. So there's still a lot to learn, but right now we think it's safe. And we think that if they're cryopreserved, that they're going to be COVID-free, but I don't have anything definitive.
Okay. So that's all that I have, unless somebody else wants to type something in the chat.
You know what? I heard that there was a question about general liability for fertility centers. I'm not really sure what that question was addressing. If it's about, can you get sued? Perhaps that's something that I'm going, maybe we should move to another format. If whoever gave that question wants to explain it a little bit more, that would be great. And maybe we could address it better then. Nidhi, Peggy, did you have anything to add?
I had a follow-up question about the virus issue. I know with HIV, in semen in particular, you will wash it, for lack of a better term. But is there any known virus that actually is carried in an embryo? I mean, Ebola or the flu, or
don't know the answer to that. That's a good question. Because again, right now we're doing a lot of this, as you know, Nidhi, by analogy, comparing this to SARS, to MERS, to Ebola, but I haven't heard anybody, I haven't read anything. So if any of the audience knows and wants to share with us, please do. Any other questions, Monica, that have come through?
Not that I see, unless if I missed anyone, just type it in now, but I think I was keeping track.
Okay. Well, then I'm going to thank our panelists, Mary Ellen McLaughlin and Nidhi Desai, and I gave you a new name, Mary Ellen, and Peggy Swain. Thank you very, very much for being here, for answering our questions, and for giving us an awful lot to think about as we all start to reopen and get back to business. I appreciate you being here.
Well, thank you.
Take care, everybody.
Thank you.
Nice to see you all.
Thank you.
Take care. Thanks, everyone.
Thank you.
Bye-bye.
Bye-bye.